So Miller v. Becerra, what exactly is this case? This is a case that was filed by the Firearms Policy Coalition, and big shout out to the Firearms Policy Coalition. Them, along with some other advocacy groups and some other plaintiffs, filed a complaint against the state, and the sum of their complaint essentially is that the Assault Weapons Control Act is a violation of the Second Amendment. So the big hoopla surrounding this case mainly stems from the plaintiffs in this case filing a motion for preliminary injunction. And the motion for preliminary injunction was filed on December 6th of 2019. And so right around before Christmas, there was a big uprising when this motion was filed. People starting to talk about, well, maybe we're going to get another Freedom Week. So before I dig too deep into the motion and things of that nature, I think it's critical that we kind of get some background knowledge on this case and the cases that it references and the statute that it's challenging. So the first foundational information that you're going to need is what exactly is the Assault Weapons Control Act. The Assault Weapons Control Act of 1989, or the AWCA that you'll see it referenced a lot, essentially established penal codes 3050, the entire section. This statute established those penal codes which classified certain firearms and categorized them as assault weapons as defined by California. And what the AWCA did is that it threatened certain criminal penalties for the acquisition, transportation, use, transfer of these specific firearms. The AWCA, as it was originally instituted, only covered a specific set and had a list of specific makes and models that were defined as assault weapons. But soon, California being the way that it is, expanded on this list. And so what happened was the AWCA was later expanded to include firearms with common characteristics, and said if these specific characteristics are on a specific semi-automatic rifle, that rifle then becomes an assault weapon. And so again, these specific characteristics are large capacity magazines, pistol grips, collapsible or telescoping stocks, vertical foregrip, or a flash hider. Those are the main ones that you need to know of. And that's again section 30515A. Is when you start having the A1 is when you have those specific characteristics. Important for that is it talks about a centerfire rifle that does not have a fixed magazine. And so that's where you start to get into the nuances of what happened after this was instituted. People started configuring rifles in specific ways to avoid the language of this statute. And so part two of this, a semi-automatic centerfire rifle that has a fixed magazine, so this is different than a not fixed magazine, with a capacity to accept more than 10 rounds. And then part three talks about a semi-automatic centerfire rifle that has an overall length of less than 30 inches. So what this statute essentially did is it expanded the original language of the AWCA to go beyond the list of just the specific make and models listed originally in 1989 to include rifles with certain characteristics, fixed versus not fixed magazines, and things of that nature, total length of the rifle. What it did is it expanded on the language to include more things to fall under the category of an assault weapon as defined by California. And so another critical thing that we kind of need to go over real quick has to do with the Duncan v. Becerra case, which was decided by the same judge, Roger T. Benitez, as some people are calling him Saint Benitez. This case is used heavily in Miller, and what the plaintiff actually does and what the Firearm Policy Coalition does, which is it's very smart strategically for a lawyer in a law firm, or when you're writing to a specific judge, is to cite their words directly back to them. So what they did is they used the decision of Benitez in Duncan for Miller, and they cite to the judge his specific words. And so Duncan is very critical for what's going on in Miller, because what the plaintiff does is they springboard off of Duncan to make the argument of why the AWCA actually violates the Second Amendment. So what happened in Duncan is Judge Benitez issued a preliminary injunction on the ban of large capacity magazines. And for a week period, it was legal for California citizens to purchase magazines that held more than 10 rounds. And it then became this weird gray area where you legally purchased them, you were now in lawful possession of them, and you could lawfully use those magazines that you purchased in a rifle as long as it didn't offend the A2 version of the language that I cited earlier of the AWCA. And that is why people are saying, well, Miller, this case here, might be the second or Freedom Week or 2.0 Freedom Week. So that's your foundational knowledge and background about, okay, what is the AWCA and then what happened in Duncan. And so the bulk of the argument made in Miller in the motion for preliminary injunction has to do with proving that they are likely to succeed on the merits at the hearing here in this case. And that is that they are likely to prove that the AWCA is a violation of the Second Amendment. And I'll try to not get too deep into the legalese of what all the preliminary injunction entails, the legal standards, but I'll just give you guys a basic overview right now. Essentially, the legal standard for a preliminary injunction that the plaintiff is seeking here is they have to prove that they are likely to succeed on the merits and that they will likely suffer irreparable harm in the absence of the preliminary injunction or the preliminary relief or the relief that they're seeking. And so I'm going to try to take you quickly through each main argument that is made by the plaintiff. And so the first main argument that they make in their preliminary injunction is that the AWCA violates Heller. And as many of you know, Heller is a Supreme Court decision. And the main argument that's used and is cited for Heller is that the government cannot regulate firearms which are in common use. And very interesting in this section, when saying that the AWCA violates Heller, what they do is, what the plaintiff does here is they cite language from Duncan directly back to Becerra. So this is his own language being cited back to him. So what they say is, as this court has recognized, Heller's categorical analysis asks simply whether the arms being regulated or banned are in common use for lawful purposes. So here they're saying, you already said that you cannot ban commonly used firearms or firearms that are used for lawful purposes. This is your language. This is what you had said. What the AWCA does is a direct violation of what you said cannot be done. And then the plaintiff closes out this section very nicely by saying, just like the District of Columbia's ban on handguns in Heller, the city of Chicago's ban on handguns in McDonald, the California's ban on large capacity magazines in Duncan, California's sweeping ban on this ever expanding category of firearms is categorically unconstitutional, full stop. And so the bulk of the strength and the bulk of the argument made in the motion for preliminary injunction has to do with common use. In this section, in arguing why the firearms regulated by the AWCA are common use, the plaintiff cites to Heller. And this specific language in Heller is, it says, we think it is clear enough in the record that semi-automatic rifles and magazines holding more than 10 rounds are indeed in common use. So if these firearms are indeed in common use, the AWCA's regulation of these semi-automatic rifles that hold more than 10 rounds would be a violation of the Second Amendment. And then this section, the plaintiff goes on to essentially give some statistics and some additional arguments of why these firearms are indeed in common use. In 2016 alone, 2.2 million of these rifles were either manufactured or imported into the US. And then they also say in 2019, 96.5% of firearm retailers have sold these types of firearms that would be prohibited by the AWCA. And then they go on to give historical support. And so essentially what they argue is these type of firearms have been sold since 1950 with these standard characteristics, and they have been commonly used historically since then. And then again, the plaintiff goes on to cite the language in Duncan back to Judge Benitez in the motion. And in this section, what they cite back to him is, over the last 3 decades, One of the most popular civilian rifles in America is the much maligned AR-15 style rifle. Manufactured with various characteristics by numerous companies, it is estimated that more than 5 million have been bought since the 1980s. These rifles are typically sold with 30-round magazines. These commonly owned guns with commonly sized magazines are protected by the Second Amendment and held a simple test for responsible, law-abiding citizens to use for target practice, hunting, and defense. And so then we start getting into kind of the meat of the arguments made in the preliminary injunction, essentially where the plaintiff argues that the AWCA bans arms that are well suited for self-defense, and then the plaintiff gets into specific reasons why these type of firearms are well suited for self-defense. And in summary, what they argue as far as self-defense is that these type of arms are beneficial for lawful gun owners in life or death situations, that the standard characteristics that are prohibited and banned by the AWCA actually enhance accuracy, control, and safety, and these type of characteristics should actually be encouraged and not banned. And then as another support of why the AWCA is a violation of the Second Amendment is that they say that the AWCA bans arms that are well suited for militia. And so one of the last things we're going to look at is the motion to stay. Just a couple weeks ago or a week ago, the Firearms Policy Coalition put out a tweet of Judge Benitez is going to hear the case. I think it was January 29th. And everybody was like, yay, hurrah, we're Freedom Week 2.0, yay, we're going to get our assault rifles. It was confusing because if you just looked at what had been filed, it was pretty obvious that there was a motion to stay and an ex parte motion to stay that was pending. Now we have some hindsight in at that Judge Benitez actually denied the motion to stay, but it was critical because ultimately what happened is the hearing got pushed out from the end of January to February 6th. But it was confusing why a lot of people looked over the motion to stay because it was a very critical and telling aspect of this case, and I'll explain why. Primarily what happened in the motion to stay, as far as what the defendant argued, is there are two cases pending before the Ninth Circuit. The defendant in this case essentially says you have the Rupp case and the Duncan case before the Ninth Circuit. They both deal with issues similar to what's happening here in Miller. And Judge Benitez, why don't you just say, hey, I'm not going to hear this issue until the Ninth Circuit decides on these two. Now, if Judge Benitez did have some heartache about, or heartburn, or had some issue about how things played out in Duncan, or how his decision in Duncan played out, he could have easily said, yeah, you're right. I'm not going to hear this issue until the Ninth Circuit decides these two cases. What they did is they offered him an easy out. And a lot of people were overlooking how critical this portion of the case was. Why it's critical is Judge Benitez did not take the easy out. So this is actually exciting for us. He does not seem to have any regret about his prior decision in Duncan. It seems like he has no issue hearing this new assault weapons Second Amendment case. So after all this, where does that leave us now? The hearing has been extended out to February 6th. So if you are seeing any videos talking about, well, end of January, January 30th, that's the day that we're going to hear this. That's the day Judge Benitez is going to decide that. That's not the case anymore because he heard the motion to stay and because he denied it. He did decide to extend out the hearing. So now the opposition briefs by the defendant are due January 23rd, and then the reply briefs of the plaintiff are due January 30th. And so all the briefs will be in by the end of this month. The case will then be heard on the 6th of February. And so all the information that the judge will need as far as papers will be in by the end of January. Now, at the hearing, there will be oral arguments, some evidence can be presented. Whether or not Judge Benitez will actually decide at the bench, we don't know. But but he will have all the papers in beforehand. So I think it is possible that he could rule at the bench. It could be possible that a few days after he'll make his decision. As far as what my recommendations would be to you guys, I would anticipate that February 6th, he would rule at the bench in favor of the motion for preliminary injunction. I think it's always safer, especially when it has to do with the Second Amendment issues in California, to hope for the best, because like we saw in the first Freedom Week, is a lot of people were caught off guard and didn't even hear about it until after the week had passed. And so I think in preparation of February 6th, get your finances together, get whatever items you need to get together to build your AR-15, whatever. We don't know exactly in what form his ruling will be, but you want to be ready to go just in case he decides at the bench on that day. If he says the AWCA violates the Second Amendment, that these prohibitions of characteristics violates the Second Amendment, and therefore citizens in California should be lawfully allowed to have these characteristics on their firearms, or regardless of whether it's a detachable magazine or fixed magazine, whatever form his decision is, we need to be ready to take action so that we are legal within whatever time period we've been given. Now, I know a lot of people are saying it's going to be Freedom Week 2.0. We don't know necessarily. It might be a week. It could be a day. It could be 2 days. It could be a month. It could be a year. We don't know. It could be until the Ninth Circuit hears the decision. But my recommendation to you is you need to be ready to do whatever you need to do. I will be doing updates as we get a decision by Benitez. I'm trying to get you guys the best information I can. It takes a lot of my time. I'm an attorney, so I work a lot. And then I come home and then I do research or I make videos for you guys. So it's not easy. If you guys would like to support the channel and you appreciate what I'm doing and you would like me to keep making these videos, there's a couple ways you guys can support the channel. Of course, you could always subscribe. You guys could also use the affiliate links down in the details. I get a percentage of all the sales that you guys produce through those affiliate links. What I actually like to do is I don't use them just specifically for those items. What I do is I have other, YouTubers that I follow, specifically Second Amendment YouTubers that I follow. And anytime I'm gonna buy anything on Amazon, I use their links to make sure that they get a little bit of kickback and get a little bit of support so that they can keep doing what they want to do. And it's an interesting way to force Amazon to put money in the hands of people fighting for the Second Amendment. Another way you guys can support the channel is, as you see, I'm wearing this sweater here. This is a company I'm an affiliate of. It's called Vigilant and Humble. They make some really cool sweaters, shirts, other clothing items. Really cool company. I'll have a link down in the description to their website. I always appreciate you guys supporting the channel. You guys have been awesome. We have more than 5,000 subscribers now, which is crazy. I just decided to start making some videos because I thought it'd be helpful to some of you guys, because there's a lot of questions that I had that I didn't see a whole lot of answers to. So I thought, I'm gonna make some videos that might help some other people, and you guys have responded amazingly, and I can't thank you guys enough. Thank you guys for watching, and never forget, a nation that draws a great distinction between its scholars and its warriors will have its laws written by cowards and its wars fought by fools.